I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we will be sharing another compilation video. You guys have been loving them. I'm loving the responses. All of the commentary that you guys are placing in the comment section has been really fun to read that. And the reason why these compilation videos are great is because it shows some past moments that we shared. Two, it gives an opportunity for those that have never seen these proceedings to see them. And three, if you have seen them, there are now chapters in these videos where you can skip to a judge that you may not have seen. So with that being said, let me give you the rundown on these judges and we'll hop into these proceedings. First, we're going to be in the courtroom of Judge John Sanders out of the state of Kansas. Next, Judge Victoria Shackelford out of the state of Michigan. After that, it will be Judge Donald Chisum, also out of the state of Michigan. And last but not least, Magistrate Hillary BRALEY out of the state of Michigan as well. With that being said, guys, just like any other compilation video, there will be no commentary because I've done original commentary on all of these proceedings. So with that being said, I'm going to get out of the way so you guys can enjoy these proceedings. Thank you for joining me always. And without further ado, guys, let's get into these proceedings.
Are you Mr. Hanna?
Yeah.
All right. This is case number 2024 CR 420, State of Kansas versus John Hanna. Mr. Hanna, it looks like you've been charged with one count of sexual battery. That is that's a Class A misdemeanor. That can carry up to a year in the county jail and a fine of up to $2,500. So let's talk about how you might want to handle your case. This is just the time just to let you know what your charges are. Did you get a copy of the charges against you?
Of course not. I haven't even been found guilty on the sanction, the write-up while I'm in here.
Well, of course you're not going to be found guilty yet.
But I mean, I don't mean to interrupt you, but that's the procedure. And I mean, we could talk to the Department of Justice about the jurisdiction of the case as well. We can take it to that extent, but you can go ahead and continue. I would like to challenge the jurisdiction on the charge. I want to state that for the records as well. Will you continue? My apology.
Mr. Hanna, I'm going to run this court, not you. And you can start off with the sovereign citizen crap about jurisdiction and everything else if you want to.
I'm saying, I understand that. I'm just saying, but
it's not going to
talk
get
to the Department of Justice as well, because you know who the director of the Department of Justice is, right?
That's just fine. You can do whatever you want.
We'll talk to him now.
Anyway,
he'll be waiting on an indictment on you.
In any event, you're charged with one count of a sexual battery, Class A misdemeanor. You're going to have an attorney to represent you, or do you want the court to appoint somebody to represent you?
You can appoint me one, and I'll have an attorney later on when I find one.
Okay, I'm going to go ahead and give you a hearing date on the misdemeanor control docket. Your next hearing is going to be November 18th at 9 o'clock with Judge Webster. That can be by Zoom. Mr. Canfield, what's the state's recommendation on bond here?
Your Honor, in addition to the sexual battery against a deputy, the defendant also has been convicted of aggravated domestic battery, aggravated battery, and aggravated escape from custody. So at this time, the state's recommendation will be a $7,500 cash or surety bond.
Those charges aren't even my record. For legal detainment and corpus.
Very well. The court's going to go ahead and set your bond at $7,500. 30.
Maybe he's facing the grand jury.
If you can, sounds like you can afford your own counsel, so I'll let you go ahead and see about doing that. If you can't afford it, when you get around to your next hearing, you can ask the judge to appoint counsel for you. But I've given you your next hearing date. You know what your bond is. You'll need to stay with the sheriff until such time as you are able to execute your bond.
And so we didn't address the jurisdiction issue either, right?
The
Thank
fact that you're where you are and I'm where I am means that I have jurisdiction over you.
All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, you know, I've been researching the law and, you know, the powers of the banks, and it's more of a accuracy of the actual accounting that I'm trying to make sure, and, you know, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, you know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, I mean, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. I mean, that was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You know, you say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those
so,
are the questions.
Okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you?
My personal security, which I'm entitled to rights to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about, I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card. and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. One second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th.
Okay.
My clerk's indicating.
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition. Hearing date will be January 9th at 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set. All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and it was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for the inconvenience. So that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. I'm setting a date. So what do we need discovery on this? Mr. Goethals, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands?
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you, Mr. Arnold. Mr. Arnold, I have ruled against you. I am allowed to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
Mr. Simpson, can you hear me? Mr. Simpson?
I go by Matthew Aaron Simpson. The person that you're speaking on, I don't recognize.
You go by Matthew Simpson, correct?
I go by Matthew Aaron Simpson, but the name that you're speaking on behalf of, I don't recognize.
Name that I'm speaking of on behalf of.
Yes, I'm the executor of the illegis.
Oh, you are.
I'm the agent majority. I'm not a minor. I'm competent. And I would like to declare that I, Matthew Aaron Simpson, would like to state on oath, on the record, that I am declaring a national non-citizen.
Well, your status as a citizen is not really central to these events that bring us here. What brings us here is the fact that you owe money to the court for two different matters, one from 2022, the other from 2024, a total $480. I'm going to recall the warrant for your arrest. How did you come to be arrested?
I don't recognize.
Who brought you to the jail?
I don't recognize.
Your Honor, if I may, I'm appointed this morning for arraignment purposes only, and I know that Mr. Simpson does not wish me to represent him, and obviously that's up to him. But I will let the court know that I did check the inmate screen, and it looks like the 44th District Court is the only matter holding him currently. And he also has a warrant out of Grosse Pointe Farms for a traffic arrest, but this is the only thing in Oakland County, it appears.
Thank you. Well, Mr. Simpson, it really doesn't matter what you recognize or don't recognize, because you're dealing with the power of the government. whether you recognize that government or not. So what we have to do here is figure out how to negotiate a path for you, whether you recognize the power or not. And the fact that you owe this money to the court appears to be the only thing keeping you in jail. It is not the intent of the court to have you be in jail for $480.
I understand that according to
Where do you
18
stay now, sir?
on Earth,
Where do you stay?
on Earth,
On Earth. You have a particular spot on Earth?
no,
Do you have any spot that you have mail sent where you can get mail that's addressed to you?
I don't recognize.
Simpson, you're not making this easy on yourself. You're creating difficulty for yourself.
I don't have a.
Where do you get your mail?
I don't have a place of residence.
Where do you get your mail?
I don't.
Who feeds you?
Who feeds me?
Yeah, who feeds you? When you're not in jail, how do you eat?
I put food in my mouth.
Okay. Where do you get the food?
Earth.
Do you have employment?
I don't recognize.
Does anybody pay you for working for them?
I don't recognize.
Well, you recognize the fact that you're behind bars now, do you not?
I don't recognize.
Reset the show cause. And the bond is $480 cash.
I don't recognize.
You can recognize or not. Doesn't change the fact that you're not going to get out of jail until $480 has been paid on your behalf. Whether you recognize that authority or not, it's happening.
I'm an executor of Matthew.
You can be an executor or you can be an executor. It doesn't matter. There's $480 needs to be on the table before you're released. We're done.
I would like to put that into my foreign trust.
You can do whatever you like, sir. Have a good day.
Okay.
Good morning. 14B District Court is now in session. This is Magistrate Hillary BRALEY presiding. Okay, and I need you unmuted at the jail. There we go. Can I have your name, please?
For the record, my name is Thomas Stiver II. I'm the natural person of the living man. How we doing today, Miss BRALEY?
We are upright, if nothing else.
Great.
So, okay. And you said your name is Thomas Styron.
The second.
The second.
And then I'm the natural person, the living man.
Okay, thank you for your patience there. We had a little bit of a kerfuffle. So,
No problem.
recalling case number 19S00472, that is the state of Michigan versus Thomas Ulrich Styron, the second, you said, and also calling 24W001025, that is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. Is not the name you have attached to this case is not me. I believe that's a state created entity, Your Honor. And me being a living person, I don't my name is in proper punctuation. I don't have a all caps name nor
Okay, I'm going to cut you off right there. Okay.
I don't have no, sorry. I don't have no contracts with the state of Michigan at all, period. And so I was wondering about personal jurisdiction, subject matter jurisdiction in regards to this.
Okay. And you can continue to wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance of $210 on that. And then what you're being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening. That charges that you operated a motor vehicle on North Ford Boulevard at or near Russell Street with no license on your person. Do you comprehend the charge against you?
I do not. I don't even own a license. I canceled my license years ago.
Okay. So what you are being charged with is operating a motor vehicle without having a license on your person. So I'm not asking if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused me of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in commerce. I was traveling home.
Okay.
I wasn't doing business at all. And also from my understanding, I don't need a license to do that.
And your overstanding is incorrect, sir. But we are not going to get into that for now. You are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So
at this time, the court is going to set a pre-trial date for you. That will be before Judge Washington.
Ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pre-trial for that entity?
I hear you. And at this point, you are appearing in front of the court. You have put your name on the record. And yes, we are setting a pre-trial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that you have attached to that case.
And you can provide documentation of such at your pre-trial date, which is going to be June 26th.
So the documentation that I have published, recorded the documentation I have published and recorded on the record, on the state of Michigan record, that says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case, that's I need to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records.
So whatever documentation you have, bring it with you to your pre-trial date. That is what I am telling you, yes. So and again, that court date, June 26th. Okay, will be June 26th at 9 a.m. before Judge Washington. The court will enter a that you are standing mute to all charges at this time.
So we're just assuming jurisdiction, though, correct?
Yes.
How? From my understanding, That has to be proved before we even proceed with anything else. Am I wrong?
You are not correct. The court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before Judge Washington, where you will have your pretrial. Okay, so at this point, your hearings are concluded. You are free to stand up and tell the jail that you are finished.
I'm not threatening you. Say one more word and that's 30 days. 30 days.